Welcome to today's webinar on Stress Less, Work More. The host of today's webinar is Amanda Marquarite Robinson of Great Russell Chambers and the Barrister Group. For those of you who haven't joined our webinars before, my name is Aaron. I'm an assistant consultant at DG Legal. And just by way of a quick introduction to Amanda, Amanda is a commercial lawyer. She has an emphasis on employment law and discrimination. Amanda was called to the bar at Gray's Inn in 2000, and she now has over 20 years of experience in the employment tribunal and over 18 years of experience in the civil and commercial litigation. And with that said, let me hand over to Amanda herself.
Thank you, Aaron. It's Amanda Marquarite Robinson. I'm sorry that my name.
I absolutely butchered the name. I do apologise.
No, there's no problem at all. I'll just be brief, just to say that because we've cut into the time, it's all my fault. I apologise to everyone. People are welcome to email me with questions afterwards if there isn't time for questions and things. You're welcome to contact me if there's anything that arises from the slides that you want to ask. Feel free to do so. All right, thanks, Aaron.
Okay, that's great. Thank you, Amanda. Right, let's get the show on the road.
Stress Less, Work More with Amanda Marquarite Robinson, Barrister. The aim of this webinar is to provide an overview on the law on reasonable adjustments, provide some guidance on capability of performance in the workplace, and provide guidance on managing your own stress in the workplace. Topics that will be covered in this webinar include who am I, what is stress, disability, reasonable adjustments, capability and performance, and stress less, work more. Who am I? I'm a practicing barrister and was called to the bar in July 2000. Prior to that, I was an employment rights officer for 2 to 3 years at my local and regional CAB. In that role, I covered every area of employment law and health and safety, and my first in-person appearance was in the Employment Appeal Tribunal. I am currently a member of the Barrister Group. I also own my own set of chambers. It's as a sole practitioner, which is Great Russell Street Chambers. At that first appearance in the EAT, the Employment Appeal Tribunal, I was anxious, I felt completely out of my depth, I was ill, the anxiety was absolutely incredible. I put it down to performance anxiety. When I was in the waiting room, my anxiety level was absolutely incredible and continued going up and up and up. I think I was around 22 years old, and everyone in that room were seasoned barristers who sounded like they knew the entirety of the whole of the legal system and every bit of English law. And then there was me, a CAB rep. I had been trained, but I didn't feel like I had at that point in comparison to the people I was sharing the room with. My heart was absolutely beating out my chest and my head just completely went empty. However, as soon as I rose to my feet, apart from stumbling over my name, which the full name I have is Amanda Marquarite Nanu Robinson, so you can see why I did stumble over it. As soon as I started to address the judge, my nerves dissipated and I performed my job, feeling at ease with communicating what the crux of that appeal was and guiding the judge to the documents that assisted and being able to answer questions from the judge, which if any of you have been in courts and tribunals, you know that you could probably be asked anything at any time, and being able to answer is the gift, although not always necessary. What is stress? It might sound a simple question, but quite often, while we feel that we can identify our own stress, it's helpful to be able to identify that of others, or find something that's tangible to identify what it is that indicates that something is stress. So, stress, according to the NHS website, is the body's reaction to feeling threatened or under pressure. When we are stressed, our body releases a hormone called adrenaline, often called the fight or flight hormone, which usually gives us a boost or motivates us to act quickly. So it's not always a negative thing, in other words. But too much stress can affect our mood, our body, and our relationships, especially when it feels out of control. It can make us feel anxious and irritable and affect our self-esteem. Experiencing long-term stress or severe stress can lead to feeling physical, mental, and emotional exhaustion, often called burnout. Long-term effects of chronic stress. The long-term effect of chronic stress causes wear and tear on the body, such as the following examples. On the digestive system, the effect it can have is stomach ache, which is common due to a slowdown in the emptying of the stomach. Also diarrhea due to more activity in the colon. Obesity, because there is an increase in appetite, which can lead to weight gain. Being overweight or obese puts you at risk for diabetes and cardiovascular disease. It can affect the immune system. Weakening of the immune system so that you're more likely to have colds and other infections. It can affect the nervous system, creating anxiety, depression, loss of sleep, lack of interest in physical activity. The memory and decision making can also be affected. It can affect the cardiovascular system. There can be an increase in blood pressure, heart rate, blood fats. There can also be an increase in blood sugar, glucose levels, especially in the evening hours, and appetite, which contributes back to the weight gain. All of these factors are risk factors for heart disease and stroke, as well as obesity and diabetes. Some of the signs and symptoms of stress, which are listed on the NHS website, are: we may become irritable, angry, or tearful. We may feel worried, anxious, hopeless, or scared. We may struggle to make decisions, having racing thoughts or feeling overwhelmed. Physical symptoms that we may experience are stomach problems, stress headaches, pain, for example, muscle pain. We can experience dizziness, sickness, and feeling faint. Include fatigue, depression, chest pain or pressure, including rapid heartbeat, difficulty breathing, menstrual cycle irregularities, erectile dysfunction, and loss of libido. You therefore may deem it important to continue listening right to the end when you get the tips on how to avoid stress and reduce it. In terms of employment legislation, the definition of disability is in Section 6 of the Equality Act 2010. Section 6. A person, P, has a disability if P has a physical or mental impairment and the impairment has a substantial and long-term adverse effect on P's ability to carry out normal day-to-day activities. Physical or mental impairment. An exhaustive list would not be wise, but on gov.uk website some examples are given as follows. Sensory impairments such as those affecting sight or hearing, impairments with fluctuating or recurring effects such as rheumatoid arthritis, ME, chronic fatigue syndrome, fibromyalgia, depression and epilepsy, progressive diseases such as motor neuron disease, muscular dystrophy and forms of dementia, autoimmune conditions such as SLE, organ-specific conditions such as asthma, cardiovascular diseases, including thrombosis, stroke and heart disease. Developmental, such as autistic spectrum disorders, ASD, dyslexia, dyspraxia and other learning disabilities. Mental health conditions with symptoms such as anxiety, low mood, panic attacks, phobias or unshared perceptions. Eating disorders, bipolar affective disorders, obsessive compulsive disorders, personality disorders, post-traumatic stress disorder, and some self-harming behaviour, mental illnesses such as depression and schizophrenia, for example if they're produced by injury to the body, including the brain. Substantial or long-term adverse effect. The easiest way to look at this, because it is a low threshold and shouldn't be overthought, is that it's more than trivial or minor, and that is it. That is the definition. More than trivial or minor. Examples of normal day-to-day activities. Remember, this is not an exhaustive list, they're just examples, and just be a bit careful to think through how, for example, if you're preparing an impact statement for a claimant, you usually, in practice this is what I do anyway, I ask the person what they feel has become different or difficult since they have become disabled, or if they're disabled, changed in an impact or effect, how that impact has impacted upon them in particular. And then I go through their day, so I'll say, you know, what happens at the beginning of the day, you know, what is there any difference between what you used to do and what you do now, and then when you go to work, do you have any aids to go to work, do you have any assistance to go to work, when you're in work, what adjustments have been done already, if any, and then go through you know, what the difficulties or ease of working is. If there's been aids, for example, or adjustments, then they can usually identify, well, before that it was like this, and now it's been eased by the adjustment, for example. So the conversation is to be had with the claimant about the impact on them in particular. This list is just giving you some guidance on what is considered to be examples of normal day-to-day activities, but it's not an exhaustive list, because the impact on the claimant comes from the discussion with the claimant about what the impact has been on them. So the examples of normal day-to-day activities are as follows. Communicating with other people. So in practice, I've seen people being unable to communicate on telephones, having difficulty communicating face-to-face, having difficulty communicating via email. Some people haven't been able to go into work because of their disability, because they don't want to be communicating at that time. So there's an avoidance of communication as well, so that can come into it. The next one, driving, would never apply to me because I can't drive anyway, but driving is considered normal day-to-day activity for most people. Filling in forms, again, this is considered normal day-to-day activity. However, in practice, I found that a lot of people cannot fill in forms anyway. So be a little bit careful with that, I would say, because realistically, if someone wasn't able to fill in a form before, then that's your answer, isn't it? But if there's been a change, that's the indication that there's an impact on their day-to-day activities. So it's the change that you're looking for, or it's the impact which gives you an indication that it's related to the disability or because of the disability. So if they weren't able to fill in forms anyway, then you're not going to be listing it on an impact statement. But it's just to be aware of that some people find that their disability affects their ability to fill in forms. Following instructions. So this can definitely, with certain mental health conditions, in my experience, I've seen that people have started to have difficulty following instructions, or are checking on themselves, or overthinking it maybe sometimes, just to give you some examples. So again, it is considered a normal day-to-day activity to be able to follow instructions. So if a claimant has found that they're finding it difficult to follow instructions, that's an indication that yes, there has been an effect on their normal day-to-day activity, at least in that respect. So again, that's something to think about in terms of whether there's been an impact on their ability to follow instructions. Again, if someone wasn't ever able to follow instructions before and it's got no connection to their disability, then of course you need to be considering whether you put on an impact statement or not. I would say that you shouldn't. But if it's because of their disability or related to their disability in any way, then of course it needs to be on an impact statement. Continuing on with the examples of normal day-to-day activities, getting washed and dressed. Sometimes people are a little bit alarmed by this one, but of course if someone has serious mental health problems, we know if you read the research that there can be an impact on people being mentally able to get washed and dressed. However, there's also the other side of it, physically being able to get washed and dressed. So this can either be because someone cannot engage with being able to get washed and dressed, doesn't feel like it, or physically cannot get washed and dressed themselves. So it's considered a normal day-to-day activity. It is one of the key things because it's always good to check it, because in my experience, definitely you'd be surprised how many people cannot physically get washed completely or dressed completely themselves. They might ask a partner, a friend or a relative to help them with a piece of clothing, etc., or buttoning something up, for example, and it might seem simple to them because they've got used to it, but actually it is relevant because a normal day-to-day activity for the average person is that they are able to get washed and dressed. And so if there's an impact on that, it's important that that is recognised and in an impact statement. Going to the shops. So again, there can be a lot of different reasons that this can affect people, or that they can see there's a difference between now and the past when they were able to go to the shops. So again, you can look at the mental side and the physical side. So someone might not be able to face going to the shops, might not be able to face going out in crowds or face other people. They might not be able to go out of their house. So that's usually related to mental health, physically not being able to go to the shops. So the expectation is that we're all able to go to the shops ourselves, do our shopping and be able to bring it back home. If someone isn't able to do that, then that is a normal day-to-day activity that they are not able to do. So it is important again to just check with people. And if they say, oh yeah, I do go to the shops. I've had this situation before where someone said, oh yes, I do go to the shops. Of course I do my shopping. And then I say, well, is someone coming with you? Are you using a walking aid? Are you being driven there? Is someone carrying a shopping for you? All of those things are relevant because, of course, if someone can't shop independently themselves, then there is an impact on their normal day-to-day activities. Preparing and eating food. Again, we are expected to be able to, one of the things that we should be able to do on a normal day-to-day basis is prepare and eat food by ourselves. Again, it is important to ask this as delicately as possible because I think, we have to be a little bit diplomatic when we ask people some of these questions. But preparing and eating food, because it's considered a normal day-to-day activity, if someone cannot do it, then again, it should be on an impact statement. So just be aware of that. Sitting down and standing up. Again, it's a normal day-to-day activity, and so if someone cannot sit down on their own, or can't sit down at all actually in some cases, or cannot stand up unaided, then again, it's normal day-to-day activity that they are not able to do without assistance. So again, just be aware of that. Using a computer. Now, it's considered a normal day-to-day activity, but I know that, you know, if I spoke to my uncle that's 85, he might say, no, it's not normal for him. And I've got another family friend that's in his 60s that panics when he's using a computer. So I'd be a bit careful about that. It's on the list as an example, but be a little bit careful about that, because if someone wasn't able to use a computer before, then you know, it's indicative that it's not because of the disability. Of course, you can just check if it's because of the disability, because you can ask the right questions to the claimant, and you can check medical reports, or with the GP, ask the claimant to check with the GP anyway. But just be a bit careful about that one. So even though it's on the list that using a computer is considered a normal day-to-day activity, I query whether that can be true in every case. Then writing is considered a normal day-to-day activity. Again, be a little bit careful with that. Maybe, you know, be a little bit sensitive about that, because there are still some people that cannot read and write in the UK. And I know that sounds pretty ridiculous, and you might think that it's rare, but in my experience, it's not that rare. It is rare, but it's not that unusual to come across someone that has problems, real problems with reading or can't read, and serious problems with writing. So the key is, can they do it or not do it, and what is the reason behind not being able to do it? So just be a bit wary about just assuming because, you know, someone can't do these activities, whether it's because of the disability, or because, you know, you just need to check, you need to think through what it is that's causing it, and whether they were able to do it before the disability or not as well. That's obviously key. Is the claimant disabled? The burden of proof is on the claimant, which includes establishing that they are disabled under the Act, under Section 6. Once the complainant makes a prima facie case, the burden shifts to the respondent or the employer. The exception to that is where an employer or respondent agrees or accepts that the claimant is disabled under Section 6, as defined in the Act. If they accept that, then there's no need for the tribunal to review the situation and make a determination. However, it's usual practice, in my experience, for employers to deny that there is a disability under Section 6. In fact, quite often, I would say that some employers do it as a matter of practice and haven't really assessed what they knew at the time, you know, whether they knew that the claimant was disabled, and also whether it falls under the Act. They haven't done that assessment, and when you do the assessment yourself, you do see that it's quite obvious that the claimant is disabled, and therefore there's that feeling as a representative for claimants from time to time. Obviously, I do represent respondents as well, but when I'm representing a claimant and someone has taken issue with a disability, or whether the claimant is disabled or not, I don't think it's proper to do that if on analysis it's really obvious that they are. So obviously the respondent can deny it and put the claimant to proof, so make the claimant prove it, but you know, for me, I just think it's a waste of time and money for both parties if it really is clear that the claimant had a disability at the relevant time. So just so that you know, that's just something that I've experienced in practice. So also in practice, we will have the impact statement that I've just referred to, and medical evidence. Usually we'll have medical evidence, but the relevant medical evidence, not all of the medical evidence. Again, just to note that it's quite frustrating when we have every single bit of a claimant's medical evidence in front of us in a tribunal, which is a public hearing, and there is no need for it. All that is needed is the relevant medical evidence. So again, please be aware of that it's better to have what's needed rather than excessive amounts of information that you do have to read and go through as well. And if it's not relevant, then not only are you wasting your time, you're wasting clients' money, but also those documents, in my view, shouldn't be in the tribunal. So it should be relevant medical evidence solely. And then the impact statement, as I've just gone through a few moments ago, will include a reference to the normal day-to-day activities. So just so that you know, in case there's anyone that doesn't know, an impact statement is a statement by the claimant for use in proceedings, which as a minimum sets out what the disability is or disabilities are, when the disability started or was diagnosed, why it has a substantial and long-term adverse effect, what day-to-day activities are impacted. So for example, those things that we've gone through, so communication, driving, filling in forms, following instructions, getting washed, going to shops, preparing, eating food, sitting down, standing up, etc. Those will be analysed, and obviously you would have a conversation with the claimant to see if there's anything else, any other day-to-day activities which are impacted. Why the claimant can't do those activities or a particular activity, and what aids or adaptations are used, including if someone else helps them. How the aid adaptation or the assistant helps them to do the activities, and what medication or treatment is used to alleviate symptoms or the condition. So there's quite a lot of information there. It's actually in the handout that I've prepared for you that'll be sent to you later in any case. But just in case anyone doesn't know what an impact statement should include, there's quite a lot of information that as a bare minimum it should definitely include that I've just gone through. Disability. Automatically protected disabilities. Conditions which are automatically protected include cancer, HIV infection, multiple sclerosis, visual impairment, if someone is certified as blind, severely sight impaired, or partially sighted. If you have any of these conditions, you don't need to show that your impairment has a long-term effect on your ability to do normal day-to-day activities. Under the Equality Act. Disability, progressive conditions. A progressive condition gets worse over time. Examples include Alzheimer's disease, motor neuron disease, muscular dystrophy, and Parkinson's. Someone with a progressive condition is considered by law to have a disability as soon as it starts to have an effect on normal day-to-day activities, as long as this is likely to be long-term. The effect does not have to be substantial, as long as it's likely to become substantial in future. Reasonable adjustments. There is a cause of action for a disabled person if there has been a failure to make reasonable adjustments. The relevant sections of the Equality Act are sections 20 and 21. The duty comprises the following three requirements. The first requirement is a requirement where a provision, criterion or practice of A's, the employers for example, puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled to take such steps as is reasonable to have to take to avoid the disadvantage. So the key words there are provision, criterion, practice, disabled person, substantial disadvantage, comparison to persons who are not disabled, and then the duty to take such steps as is reasonable to have to take to avoid the disadvantage. We'll come back to that later. The second requirement is a requirement where a physical feature puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, to take such steps as it is reasonable to have to take to avoid the disadvantage. Again, the key elements of that: physical feature, disabled person, substantial disadvantage, comparison with persons who are not disabled, the duty to take such steps as is reasonable to have to take to avoid the disadvantage. Again, we will go through this in more detail. The third requirement is a requirement where a disabled person would, but for the provision of an auxiliary aid, be put at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, to take such steps as it is reasonable to have to take to provide the auxiliary aid. So the duty is the latter part, to take such steps as is reasonable to have to take to provide the auxiliary aid. We will deal with auxiliary aids as well in a little while. The key elements of Section 20 of the Equality Act, in my view, are broken down to this. Identify the provision, criterion or practice, the PCP, which is applied, or the relevant physical feature of the premises occupied by the employer, or whether an auxiliary aid ought to be provided. In other words, identify what it is that applies within the workplace that is causing significant disadvantage for the disabled employee. So what is it that is causing the issue for the employee? What is making the situation worse for them is a good place to start, then go through the analysis. So the first step has to be to identify the PCP, and it's a requirement, obviously, of Section 20. Then you need to identify the non-disabled comparator. In practice, usually claimants are quite capable of telling you who the comparator is. So the policy applied to both parties equally, so it applied to the disabled employee and the comparator, non-disabled comparator, usually a claimant will be able to tell you who their comparator is, because they're in the workplace, they're able to see day-to-day events that are going on, how people are treated and so forth. So usually I would expect claimant to be able to say to me, well, this policy applies, but in comparison to them, I'm having difficulty being able to comply with it. And usually that's what I'd expect to see. If not, we'll come on to that in a few moments anyway, but if not, that you do need to be able to identify it with the claimant. Then you look at the nature and extent of the disadvantage suffered by the claimant in order to assess if there was substantial disadvantage. Again, we'll come on to this in a few moments. Then you look at the reasonableness of the adjustment, which is obviously very important. And again, we'll deal with that in a few moments. Employer's knowledge is extremely important and is a key element. So your key elements there are: identify the PCP or physical feature, identify the non-disabled comparator, identify the nature and extent of the disadvantage being suffered by the claimant, look at the reasonableness of the adjustment, assess the employer's knowledge. Do they know or do they not know? Should they ought to know? Those are questions that you should be thinking of. Provision, criterion and practice. The Equality and Human Rights Commission have given guidance as follows. They say the PCP should be construed as widely so as to include any formal or informal policies, rules, practices, arrangements, criteria, conditions, prerequisites, qualifications or provisions it's a very wide, all-encompassing term. So PCP, when you're looking at this, just be aware that it is good practice to look at the guidance from the Equality and Human Rights Commission, or on any part of equality law actually, but in terms of PCP, it helps you to identify when you're looking at a claimant's case, is it a PCP or isn't it? It's very helpful to just know that all of this list, that formal and informal policies to provisions, are PCPs. So just bear that in mind when doing any assessment in terms of reasonable adjustments. Examples of PCPs. So I just thought I'd note like three examples to be exact, down for you, just to give you an idea of what a PCP is, because I do have people that say I still don't understand what a PCP is, and I do have lawyer friends that say it as well, and sometimes I sit there and do wonder if something's a PCP or not, but obviously that's part of an analysis. So just to give you some help on an overview of what different things can be PCPs, I've just noted three examples. So the first one is absence management policies. So requiring the employee to maintain a certain level of attendance at work in order not to be subject to disciplinary sanctions. So that is a PCP. So it's a policy that's in place that applies to everyone, but may substantially disadvantage the disabled employee more than their comparator. So the second example, the practice of not giving undertakings, I quite liked this when I looked at it. So for example, this case example is that there was an employee that requested an undertaking from her manager that they would not rearrange roles or duties in a way that would require her to work with either of the people that had bullied her. Now I actually think, on the face of it anyway, I think that's sensible, but that is a PCP, or it can be a PCP. Obviously it's a case-by-case analysis. Don't just assume that there's been a decided case on something and therefore, because in that case it was a PCP and there was a failure to make reasonable adjustments, and therefore in this current case that would happen. Don't ever make that assumption. The analysis has to be done on a case-by-case basis, based on the circumstances of that particular case in front of you. But I just think that was quite an interesting example, and definitely something to consider, because if you have an employee that's being bullied in a workplace, it actually makes a lot of sense for them not to be working with the people that have bullied them. But also, is it going to be a reasonable adjustment is the question. But in any case, the practice is the PCP. So the practice of not giving undertakings is a PCP. And then the last one, policy that designated car parking spaces are only offered to senior management. So a worker who was not a manager but has mobility impairment needed to park very close to the office. It is likely in those circumstances to be a reasonable adjustment to the employer's car parking policy to provide the worker with a designated parking space. So just so that you're aware of just, a few examples of PCP. Examples of physical features. Any feature of the design or construction of a building, exit or access to a building, furniture, materials on premises. It also includes things like steps, stairways, curbs, exterior surfaces, paving, parking areas, emergency escape routes, internal and external doors, gates, toilets, washing facilities, lighting and ventilation, lift and escalators, floor coverings, signs and temporary and movable items. But this is not an exhaustive list. But those are just some examples of auxiliary aid. An auxiliary aid is something which provides support or assistance to the disabled person. Examples of auxiliary aid are technology or equipment intended to assist a disabled person, for example, a hearing loop. Auxiliary aid includes auxiliary service, For example, a sign interpreter or support worker. And it can include the provision of specialist equipment such as an adapted keyboard or text-to-speech software. So those are just a few examples of auxiliary aid. So there is a requirement for a non-disabled comparator. You have to identify the comparator. Claimants, like I said earlier, are often able to identify their comparators very easily, but whether they have or haven't, you still need to be able to assess with the claimant who their comparator is and identify the correct comparator, because obviously claimants do also make mistakes about who the correct comparator is, or there might be a better comparator. And in practice, I would say, yes, of course, if you have a lot of comparators and you think it's proper to do so, then you plead that. But in practice, you might want to limit the amount of comparators are to the actual ones that are the very good examples of comparator. So rather than have, say, for example, 8 comparators, that would be a red flag to me, to be honest. So identify the correct comparator in respect of, in comparison to the claimant. So that's the first thing. There is no requirement to identify a comparator or comparator group whose circumstances are the same or nearly the same as a disabled person, unlike direct and indirect discrimination. So just be aware of that. So that's a little bit of difference there. And then the PCP applies to the comparator and the disabled person. Obviously, that is very, very important, because otherwise the person that you're using as a comparator is not a comparator. The PCP must apply to the comparator and the disabled person equally. So, for example, a policy which applies to all employees, including the disabled person and the comparator, and then you would identify the comparator that is the best example to use as the comparator in a claim. So just to give you sort of a general idea of that. Substantial disadvantage. Quite often in practice, it's very difficult. It's very tempting to say more than what actually the law is on this, but the reality is that substantial disadvantage is solely more than trivial or minor. More than trivial or minor, those are the words. So that is the test. So substantial disadvantage, the test is more than trivial or minor. The threshold is low. The tribunal will assess whether such a disadvantage exists on an objective basis, but remember that the disadvantage has to be identified by the claimant before proceeding with the case. So just a few things to remember on that, but remember, substantial disadvantage means more than trivial or minor. Reasonableness of the adjustment. The tribunal should ask itself whether the PCP caused a substantial disadvantage, and if so, what step would be reasonable for an employer to take or have taken to alleviate it. And what is reasonable depends on all of the circumstances of the individual case. Just remember that it's assessed on a case-by-case basis. Employer's knowledge. The duty only arises if the employer knew or ought to know that the employee is disabled, and that the employee is likely to be placed at a substantial disadvantage because of the disability. So they can have actual or constructive knowledge, but there must be knowledge. Guidance provided by the Equality and Human Rights Commission in the Code of Practice refers to it being a good starting point for an employer to conduct a proper assessment, look at what reasonable adjustments may be required, implement any adjustments in a timely fashion. More than one adjustment might be needed, and agree the adjustment with the disabled person beforehand. Capability and performance. In my experience, sometimes employers engage their conduct, performance and capability procedures as a means of managing out their employee, when it's not proper to do so. So in other words, a veiled mechanism to oust their employee out of the business when actually it's not legitimate to engage the capability procedure or performance procedure or the conduct procedure. Disciplinary procedure. What we will not deal with today is any conduct issues. Capability and performance procedures. Usually these are only engaged where the employee is not able to perform part of their job role or perform to the standard require. So there's a performance issue which includes dropping quality or quantity of work, or that there's an issue with attendance, and or there's an issue with the employee undertaking part or all of their duties. So that's when I usually see that capability or performance procedures are invoked. Just some caution to be had here. Care must be taken where health issues, including disabilities, are causing or part of the reason for the capability or performance issue. So just bear that in mind. Engage the procedure for the right reason, as I've just said a few moments ago. Someone having a disability does not preclude an employer from following their procedures and policies, including to dismissal stage, as long as it's right to do so, but always consider if there are reasonable adjustments which should be made to the process, to the policy, or indeed the job role. So just some words of caution there to hopefully help. Just a handful of tips to manage absenteeism and illness. Always ensure that the employer and their managers are aware of their own policies and procedures. You'd be surprised how many people are not. If the employer departs from them for a legitimate reason, they should communicate why they are doing so to the employee. The employee should also be able to access the policy and procedure at all times. It's advisable that employees give prior warning of any meetings, inform them of what is going to be considered in that meeting, and offering them the right to be accompanied. Employees should be properly informed of the concerned issue, for example, if they've fallen short of the standard required, and what will happen if the situation does not improve. So setting out clear guidance, clear concerns, clear guidance, and a time frame for improvement, a realistic or reasonable time frame for improvement. Consult with the employee, for example, if there's a suspicion that the employee's health is causing an issue, explore that. And it's very important, if it is a health related reason, that you explore whether there is a disability and whether reasonable adjustments need to be made, because failure to do so is a breach of sections 20 to 21 of the Equality Act. If appropriate, obviously get medical opinion, for example, occupational health or the doctor. Always request permission from the employee, of course, and then just review the position with the employee and make sure that they're up to date and kept aware of what's going on. Always consider whether the employee can return to their job role and if any reasonable adjustments can be made or should be made. We're on stress less, work more. European health statistics for 2023 have the following information on their website. Again, the links in the pack that I've prepared for you all. Most common cause of stress, sorry for the S on that, common. Most common cause of stress is work. 13.7 million working days are lost each year because of stress, anxiety and depression. Work-related stress causes loss of over 15 million working days and £5 billion per year, which is incredible, I think, but also believable. They do also point out that not all stress is negative. 54%, if you want to pay attention to the statistic there, agree that the perfect amount of stress enables them to thrive in the workplace. So just remember that not all stress is bad stress, but we just need to be aware of which is which. So there's guidance from Champion Health as well, which is quite helpful on how to reduce stress, and they have some tips including learn to recognise symptoms of stress, understand how to respond, support employees to develop coping skills, be transparent. In my experience, that's very important for employees. So be transparent, Involve employees in decision making. Again, in my experience, that's very important. Offer training and development in the workplace, and improve working conditions or work environments. Also look at managing workload is another tip that they have, which again I think is very important. So just some guidance on how to reduce stress and how to help other people in the workplace to do that. Managing ourselves, not always an easy task, I don't think. Well, I speak for myself probably, but how to manage our own work-life balance to avoid and reduce stress. So a few tips from me. So try to have regular hours at work, try to avoid irregular hours, and try not to do long days every day of the week. Work-life balance is sustainable, so and that's what we need to achieve on a day-to-day basis or a week-to-week basis for ourselves. But 60-hour weeks on a regular basis are not sustainable, in my opinion. I applaud anyone that does that, but I would say that it's better to reduce some of the workload if you can. It depends. If you're not stressed, obviously, you can do that. But if you're feeling stressed, then try and put some more structure into your day. Another tip is have set times for emails, calls, and meetings. So for example, I have set times for checking emails that I always do. So now first thing in the morning, before anyone else starts work, I dedicate to checking emails, responding to emails, having a cup of coffee while I'm doing it. It's my morning ritual. Always do that. Before lunch, 30 minutes before lunch, always check, see if anything's come in, respond to any emails, and note if there's going to be a lengthier response. After lunch, 30 minutes, and I can usually do the longer responses that are needed in that time. And again, an hour at the end of the day. So I actually break up when I'm checking emails. I don't constantly check them. Sometimes if you've got email open and your phone's constantly going, I just wonder how you can concentrate on the work that you're meant to be doing if you're constantly breaking away from it. So that's just a tip from me in practice. Hydrate and eat properly. I don't mean to tell you what to do, but I think these do help. So eating on a regular basis is a good idea. Obviously, I would hope that we know why. And drinking water, or some kind of hydration, liquid that hydrates, on a regular basis throughout the day is good. It's good for your brain, your skin, your body. It's just something that I think that, just pay attention to. Limit caffeine intake. Well, that's a bit difficult for me, but try to, if you're feeling stressed, one of the easiest things to do is start to reduce caffeine intake and start looking at regular meal times, hydrating properly, having regular times to do things, time to go to the gym, time to go to work, time for email checking and things like that, to just because structure does, in my opinion, help. Take regular breaks. I know, again, as lawyers, it's very difficult to do this sometimes. I know that I can be sat in one place for 12, 13 hours sometimes just drafting something, or more than one document usually, I have to say. But it's really necessary to take breaks and to force yourself to take them, even when you feel like you don't need one, or you feel like you can't take one. And the reason is because you can't concentrate for long periods of, well, the average person can't concentrate for long periods of time without having a 5-minute break here and there. And it just rejuvenates you a little bit, refreshes you a little bit. Have a bit of a tea break or whatever, or a bit of a walk around. It's a good thing for your mental health to do that, rather than being sat at a desk for all of that day, or working, flat out and not taking a breath for yourself. And also take a lunch break, and I apologise because obviously I've taken up your lunch break today. Hopefully you've been able to eat your sandwiches and drink a cup of tea or have some water while you sat there, but taking a lunch break for me is very important if you can do it. Obviously when we're in courts and tribunals, we might get 10 minutes to ourselves if we're lucky, but that 10 minutes I will spend walking around the building, or walk somewhere, have a bit of fresh air and come back, even if it's brief. because it's really important, again, to just have a bit of a reset and a refresh. And, you know, our mental well-being is very important. So if you can take lunch breaks, do take them, is a tip from me. When to ask for help? Well, really, it's when to consider asking for help, because I understand. I do work with a lot of lawyers, giving advice and so forth, and I do understand that some people don't feel comfortable with raising issues in their employment, and I'm very sorry that that's the situation for some or a lot of you. I wish it was different. But the things are, if you feel overwhelmed or overworked, it is your health that's being impacted upon, and I would say to you, don't allow anyone to make you feel that you can't voice what's happening, or you know, don't be embarrassed. There's no reason to be embarrassed in my opinion anyway, but how you feel matters, and your health matters, and therefore if you're feeling overwhelmed, if you're feeling overworked, if you're recognising signs of stress, then I'd urge you to ask your manager for help, or ask a colleague to just discuss it with you. If you don't feel comfortable doing that, then you can also consider talking to your GP, is the other thing I'd say. This, I think, matters for all of us. You don't need to be perfect. When I started off, I used to think that everything had to be really perfect, and I think I only slept for 4 hours a day, maybe, which is absolutely ridiculous now. I look back at that, because you know, my work would have been good enough without being overdone, really. So I think just remember that you don't need to be perfect. Your work requires competency, and you know, do your best for your clients. But the idea that every piece of work that we do must be absolute perfection is an absolute fallacy. So don't force yourself to be in that position. Do your best that you can do for each client that you have, is what I would say. Don't put too much pressure on yourself if you can. And then remember, and I think some of us forget this, but you deserve respect and support, which includes the people around you. So you deserve to be respected by your colleagues, your managers, your boss, your clients, and you deserve support when you need it. And I hope if the only thing you take from today is that you are worthy of respect and support, that will be enough for me. Thank you for spending your lunchtime with me. Thank you for listening. Thank you for attending. Remember to stay well. Thank you very much.
Okay, thank you very much for that, Amanda. I think we all learned something there. That was really informative. So yeah, thank you for delivering that for us today. Do you have any closing remarks that you'd like to share with everyone before you go?
Just that I'm really sorry that we've gone into lunchtime. After saying, you know, I encourage people to take lunch, I feel a bit guilty. So, but yeah, like I said at the beginning, if anyone's got any questions, what I suggest doing is, if you've got an urgent question, if you're still around now, obviously you can ask something. If you want to think about it, you can email over. But what is probably best to do, in my opinion anyway, is wait till you get the info pack, because I'll actually add some more detail in there, so you've got something a bit meatier for yourselves. And then just let me know if there's anything else that you want to know about these topics. Obviously not just generally. Keep it topical. But yeah, I'm more than happy to try and help. And you know, we all learn, don't we? So if there's something as well that someone wants to ask me, and you know, email me, and I research it, I don't mind doing that either.
Okay, that's great. Thank you for that, Amanda. So as a reminder to everybody, the slides and a recording of the webinar will be sent over to you all tomorrow. This afternoon, you should receive an email asking you to rate this webinar out of 5 stars. If you have enjoyed it, please do leave feedback and please rate it 5 stars as well. And you can also give us suggestions as well for any future topics that you think we should hold webinars on that you would find value in. Our series of webinars does continue next Tuesday on the 20th of February, and our very own founder and director, David Gilmore, will be presenting a webinar on SEO success, blueprint for legal professionals, dominating Google search results. So very important webinar again, very different topic from today, but obviously a lot of value to be had there. So if that sounds like something you'd be interested in, please make sure to register, and we'll see you again next week. So one more time, thank you very much, Amanda, again for today. Thank you everyone for watching, and have a great afternoon.
Thank you very much.
Our pleasure.